Well, good afternoon. Again, my name is Michael Henson. I'm the chair of the Intellectual Property Group here at the GBA. I'm a partner at the law firm of Perkins Coie, and we do a lot with blockchain. We've had an industry group within the firm since 2013, and we have approximately 80 attorneys that touch in this space, and a handful of us do intellectual property. And I'm actually one of those IP attorneys that, yes, does code, and I do smart legal contracts from time to time. So there are a handful of us out there. So today what I really want to talk about is really what is intellectual property in general, and then I'm going to correlate that to some of the blockchain applications that are going on in the space. So let's talk about the primary types of intellectual property, and I'll try to be brief here, but let's just introduce the main ones that I think everyone is familiar with, and we'll touch base on each of them very briefly. We, of course, have patents, which most people are familiar with at some level. We have trademarks and trade dress. There's also copyrights and what I would call copylefts, and trade secrets. So let me just take each of those individually here, just as an introduction. So what is a patent? A patent is basically a negative intellectual property right. It's not a positive right for anybody to do anything. If you get a patent, it doesn't give you the positive right to practice the invention. What a patent gives you is for a limited period of time, approximately 20 years from the filing date, you can exclude others from making, using, selling, or importing the invention into the region which the patent protects. So it's a negative, personal, intangible right, okay? So there's three types of patents that exist in the United States and in many countries in the world. There are utility patents. These are the ones that I think most people are familiar with. These are patents that protect structural components and how they functionally interrelate. So manufactured devices, apparatuses, goods, systems, things of that nature. These are things that are tangible that you build. We also have design patents. So you can get a patent on the appearance of a useful article. I'll give you an example of that. Let's say you come up with a lamp that has a new little switching mechanism that you might be able to protect with a utility patent to protect the switching mechanism itself, or perhaps a lamp and illumination device that includes such a mechanism. But if the lamp has a certain configuration to it, then you might also be able to protect the look of that lamp through a design patent. So you could have multiple levels of protection for the lamp. Unlike a statue which exists to just be observed, it's not a useful article. That might be something that you can get a copyright on, but not a design patent. So design patents are limited to articles that are useful. And we have plant patents. I can tell you that if I ever see one of these, I will refer them out because I'm an electrical engineer and a programmer and things of that nature. I do not do plant patents, but in the United States, you can get a patent for asexually reproduced plants. Archer Daniels Midland is very prevalent in this area. So what are the requirements for patentability? Well, there's really three requirements in the United States and throughout the rest of the world, and they go by a little bit different terminology. But in order to get a patent, and you have to meet all three of these. If you fail any one of these tests, you're not going to get a patent. So an invention has to have a present-day useful purpose. It has to have utility. So if you were to come into my office and show me some new chemical formulation that undulates on the table, and I ask you, well, that's cool. What does it do? I have no idea. Well, you can't get a patent on it, even if it's never been done before. It has to have a use, okay? That's a pretty easy test in most cases, but I've had at least one application in my career get rejected for lacking utility. I was able to overcome it, but it happened. Novelty. An invention has to be new, which simply means it's never been done before in its exact form. If there is one difference in an invention vis-a-vis the prior art that existed prior to when you came up with it, then you have something that meets the test of novelty. The third test of patentability is called non-obviousness, or in other countries, inventive step. And what this means is that even though you come up with something that has a use, it's never been done before, it must not be something which would be obvious to do to the ordinarily skilled person in the field. What does that mean? This is a very complicated test, I can tell you. They've been struggling since a Supreme Court case in 1952 to interpret this test, and it can be a very subjective test, at least in the United States and in many other countries. But if you imagine if you've come up with an invention, you have come up with a solution to a problem that existed, an unresolved need that you have now found a solution to. So the law demands that if your solution would have been obvious to do, we shouldn't give you this limited period of monopoly to prevent others from practicing that invention. So it presumes a hypothetical that says, let's assume we have an ordinarily skilled artisan in the field of your invention, and we acquaint that person with the problem you're facing, and we expose that person to the relevant prior art in your field. Would that hypothetically ordinarily skilled person have found your solution that you came up with to be either an obvious combination of pieces of existing prior art or an obvious extension of one piece of prior art? If the answer to that is yes, then you failed the test of obviousness, or your invention lacks inventive step, as they would say in Europe, and you're not entitled to get a patent. This is one of the most challenging aspects of patent prosecution, as we say, trying to get patents through the patent office, and when patents get challenged in litigation. So back about 3 years ago, I started looking at the landscape of blockchain. This slide should more appropriately say blockchain-related patents landscape, to try to get a sense for, in the blockchain space, what does the activity look like? And so what you're seeing here is worldwide filings by jurisdictions. So this isn't a graph showing the actual issued patents, but this is the activity that we're seeing at the patent office. And you'll see a theme throughout some of these slides that China is very much leading the way vis-a-vis the United States and other countries. So we have China followed by the US, and then collectively really Europe, Korea, and other countries. This is showing worldwide grants by jurisdiction. And again, you're seeing China leading the way in the same kind of flow of the other countries. I will say that when we say blockchain patents, what does that mean? A patent has a verbal description, if you will, of the metes and bounds of the property right, just like your real estate does. Here is your property right within which people will be trespassing if they cross your property. We do that in a patent by what we call the claims. We as patent attorneys try to define the metes and bounds of what that property right is. So in my firm, we have a patent analytics group, and we go through and we monitor the issued patents. And as best we can, we try to determine if they are blockchain-related patents. There isn't a patent on the blockchain itself, but there's a lot of patents that relate to blockchain use applications and things like that. And for those of you familiar with the layer 2 solutions, these are really trying to speed up the blockchain. So in all these blockchain core technologies, if you will, there's really competing interests. People are trying to get stuff that is scalable. How many users can we onboard as quickly as possible? Is it secure? And how fast is it? Transactions per second. These are competing interests. So when we see stuff issue at the patent office on some of this stuff, they're trying to tackle some of those core concepts, but they're also looking at things of medical applications. They're looking at sovereign identity, data storage mechanisms. How can we improve the blockchain itself, okay, to make, if you will, the general purpose computer more efficient in the way it runs? And that analysis applies to blockchain as well. This graph is showing the activity in the patent space. The blue is showing the actual granted patents, okay? This is worldwide. The hash is showing pending applications, and the gray are things that are perhaps have gone abandoned or people have stopped pursuing. You need to notice and appreciate the hockey style escalation here since 2015. Now, the reason I started this at 2012 and not earlier, Bitcoin white paper came out, I think 2008, 2009. By the time people were filing in this space, it was a few years later, and patent applications aren't publicly available generally for 18 months. So the activity really started, we started seeing activity appropriately around 2015. Also in 2012 was when a famous Supreme Court case came out called the Alice test, which kind of changed how we analyze computer-related technologies, such as blockchain. So I wanted to start at 2012, because theoretically those are the cases that had to pass the muster of the Alice analysis. It might look like things are tapering off, and that's a bit misleading here, because again, we don't have a snapshot generally over the past 18 months. Those applications which are on file are generally not available for us to see. So things that were filed in late 2020, we might not even see some of these, late 2020 and obviously in 2021, we're not seeing. I expect this trend to continue, but we'll see. And again, these are the issued worldwide distribution. Again, we've got foreign in the orangey brown and vis-a-vis the US. Top assignees. Here's who's filing these patent applications. And just to be clear, there are thousands of them. I realize in the blockchain space there's a big open source community, and that's very good, but trust me, companies are filing like crazy in this space. I think because they don't know how it's all going to shake out in the end. They want to play in the sandbox. I think there's going to be consolidation. We'll see what happens. But you'll notice a lot of Chinese companies on this list, financial institutions on this list. So these are the top assignees worldwide and showing their respective US and foreign filings. Okay? This is who's filing in the US. A lot of companies that people are going to recognize on these lists. Okay? So that's a brief introduction of patents. Let's talk about trademarks. What's a trademark? Think of a trademark as any identification that one can put on their goods or services in order to distinguish them from others. Branding, source recognition. You want to adopt marks or designations that people identify your source so that you're not confused with others. I've always loved this cartoon because I think it drives this point home. Give everyone a few seconds to read it. Okay. You don't want others to adopt marks that might be confusingly similar to yours and take away that goodwill that you've invested over time. So what are some categories of trademarks? Probably familiar with all these. I'm going to go fairly quickly. Words, obviously. Apple, Dell, you name it. Okay, we have logos. We've all seen the logos. The Apple logo is an example. I don't want to keep emphasizing Apple, but it comes to mind. Slogans can be trademarks. Letters, IBM. Moving images. Packaging or trade dress. The way you present your product to the consuming public can give it distinctiveness. And if people adopt that distinctiveness, then that could be a violation of your dressing of your packaging or your trade dress. Numbers, combinations, 3M, okay? Perhaps you didn't know about some of these though. Okay, shapes can be trademarked, okay? The shape of the Coca-Cola bottle is trademarked. Colors, okay? Owens Corning pink, John Deere green, Caterpillar yellow. Placement of tags, probably the most famous one here, placement of the Levi's tag, okay? You can have aromas that are trademarked if they're distinctive enough. Admittedly, there's not a lot of them, but you can have them. Can I ask I've got some links here very quickly on the right of this. I don't know if you can click them, but you can trademark sounds. And I've got just a couple quick ones if they'll work, and we'll have a little quiz, see who recognizes them. Bingo. Next one. There you go. Okay. Not a lot of those either, but you can trademark sounds. Okay. Harley tried to trademark the sound of the Harley engine. I thought I'd pull up a couple examples for you. On the left, we have the trademark for Hyperledger Foundation. On the right, we have the trademark for Ethereum. These are records of the US Patent Office. I'm not going to go through them, but what you're seeing is an identification of the goods or the services that those marks are used in conjunction with on the top. You have the registration number, their dates of first use. When marks get used is very important in this space, and when you adopt your mark, because that can translate into when your rights start accruing when it comes to trademarks. Also just ran a search at the trademark office here for the US only, where blockchain is the word blockchain is either in the mark itself or blockchain is part of the goods or services that the mark is used to identify. 276 records as of, I think this was done January 9th, where blockchain is actually in the name of the mark, and almost 7,500 registered trademarks in the United States where blockchain is in the description of goods, okay? Notice Meta, about 8 of them. We all know Meta now. Facebook rebranded to Meta. There's the links to their registrations, okay? Companies are very, very active in this space. Trade secrets. Well, what is a trade secret? A trade secret generally can be anything that is of a business value to you that can give you a competitive advantage, the dissemination of which could help you lose that competitive advantage. So with trade secrets, we don't want them disclosed outside of people unless it's on a need-to-know, as-needed basis. So the KFC formula, right? The Coca-Cola formula, the recipe for KFC, trade secrets. Trade secrets will last as long as you can keep it a trade secret, okay? There isn't a term when it comes to trade secrets, okay? But the critical thing is that you take appropriate measures to preserve the secrecy of it. Copyrights. A copyright can be thought of as original works that are fixed in a tangible medium of expression, creative works, okay, expressive works. So books, okay, words on paper, copyright, okay, paintings on canvases, computer on computer readable media. Those are the media that it's fixed on, okay, and it can be appropriate for copyright protection. There can be an overlap between some of these protections too, because you might be able to, the lamp that I was referring to earlier might be something that you could protect through a copyright as well as a design patent, okay? So what are my rights when it comes to copyrights? Well, some of these you're probably going to recognize. The right to prepare derivative works. So to adapt the book Jaws into the movie Jaws, okay? That's called a derivative work of the underlying copyrighted work. We have the right to distribute or to make copies. Okay, the copyright holder enjoys that right and can prevent others from making unauthorized distributions of his or her work. And the right to publicly perform it. Victor Hugo's Les Miserables on Broadway, one of my favorites, okay? That's a performance right. And you have the right to display something publicly or to put a banner up or a poster of the work or excerpts from the work up, things like that. So these are the rights that a copyright holder can license out or do whatever he or she wants or what they retain when they own a copyright. Now, a copyright exists when the work is created. Upon creation of the work is when copyright protection can attach. A lot of people think you have to have a copyright registration in order to have a copyright. That in the United States, that's actually a prerequisite to initiating a lawsuit, but it's not a prerequisite to having a right, okay? So now I've kind of introduced these concepts, I want to just kind of transition into what is the role that blockchain is or can play in all of this stuff. And some of these are kind of admittedly a bit of my musings, but it's also things that you're starting to see in law journals and some of the literature in this space. Recordation of rights. This could more appropriately say recordation and management of rights. So if you think about this, if I've come up with an invention, and maybe I'm part of a company and we have a joint venture with another company, and we've got multiple people that are working on a project. It's the traditional lab notebook that everybody wants to keep. Well, what if we can put all these records on a blockchain so that we can definitively and immutably record the history of the evolution of our invention? And maybe we can record decisions along the way that decided to go off in a different direction, and maybe we're not going to protect this, but we might go off in this direction and develop over here. Well, we can record all this stuff on a blockchain. Okay, and we can permission that blockchain so that certain people can have visibility into certain aspects of that. Okay, I think there's a great deal that can be done when it comes to record management and recordation of IP rights. You could, for example, for trademarks, as you evolve trademarks or you adopt different goods or services, we can put that stuff on a blockchain. And we could have just something that is an immutable record that can tell us the provenance and the origin and the evolution of things, okay? Maybe in perhaps better ways than we're doing it right now, where everybody has disparate record-keeping systems, and now we have to merge all this information to try to figure out what the real picture of this was. I think there's a good application. There's some organizations that are doing this in this space. Transferring IP rights. So when does IP get transferred? Many contexts, mergers and acquisitions that can occur, bankruptcies, insolvencies, licensing of inventions, technology, assigning of technology. Well, when any of that stuff happens, one of the prerequisites that we have to understand is who owns what? Well, who owns what can be who created what. or collectively who created what, and what were their respective contributions to that which they created. One of the most prominent use cases of blockchain is in supply chain, and I think of this as analogous to that, is it can now be the supply chain of these evolutions of this technology and these creations of our efforts recorded on a blockchain and memorialized. And in mergers and acquisitions, we have to identify what the assets of our company are on schedules, and we can have addendums that are change over time. Well, maybe a blockchain can go out and with, I don't know, oracles and AI engines and things like that, go crawl the records at the trademark office and update that as companies, metas of the world, come up with new trademarks. And now through smart contracts, we automate that process and we update our documentation accordingly, okay? I think these days are coming. I think it's going to take private sector to initiate a lot of this stuff. The government's a little slow to adopt some of these things, I understand that, but I think these days are coming, okay? An article that I wrote a couple years ago. If you're going to spend a lot of money protecting your intellectual property, then you might want to take care that other people aren't knocking it off as best you can. So a few years back, our Customs and Border Patrol initiated a pilot program with private industry to try to use blockchains to intercept counterfeit goods coming through our ports of entry. So that and you've probably heard of this analogy before, you could almost, the Border Patrol could almost look at something and scan it and see if there's a check or an X. And if there's an X, then something happened along the supply chain. It was affected by somebody that shouldn't have affected her. They tried to change a record, or something was wrong, something is awry. That's where people are going with this kind of technology, to try to definitively determine whether or not goods have been tampered with. There are billions of dollars a year that are at risk by companies through anti-counterfeiting measures. And so it's an article that I wrote about it for Intellectual Property Magazine a couple years ago. I think this is going to be a very, very evolving space. We talked about this a little bit before, is litigation. You know, in a litigation context, as you know, evidence is obviously what comes in that people have to weigh, okay? And evidence needs to be admissible for it to come in. Well, how do you admit evidence? Well, you have to lay a proper foundation for the evidence, so that if I'm proffering evidence to the court, that I can establish that what I'm proffering is what it purports to be, okay? So it has to be credible in order for it to be admissible. I need to lay the foundation. Again, it's kind of a recurring theme you're hearing from me. If we are recording this information on a blockchain, think of chain of custody, where anytime somebody touches an item, that state changes on a blockchain. So now we have all the participants that had access to the data. Who signed the NDAs? How long did they have it? That kind of information. So if we need to establish chain of custody, or if we need to agree as to whether certain facts existed or not. We talked in one of the previous discussions about, you know, how smart contracts and things like that can be used. I think one of the things that we're going to see, perhaps in litigation, or at least I would like to see, it might be slow coming, but how many of you all have been involved in depositions? Okay, did you enjoy it? No. Okay. How many copies of documents were on that table? You have the attorneys, you have the court reporter, you have the witness. Every time a document comes in, everybody's looking at it to compare to make sure it wasn't tampered with, make sure it's the same version of that document. Well, wouldn't a hash be a wonderful thing if we could do something like that, where we could maybe streamline that process of discovery and litigation, and maybe parties could have a data set, either a discovery or maybe in their, before the litigation begins, they have this repository of information, which is their world of the historical events that occurred. So maybe we don't have to spin our wheels so much in a litigation questioning what facts are or are not in existence, because maybe the parties agreed when they created their blockchain architecture and permissioned it accordingly that they had a governance document that almost became, in some sense, the legal contract that that governs some of that stuff, so that when this information comes in litigation, we don't have to go through a lot of the exercises that we sometimes do when it comes to patent infringement lawsuits and things like that. This might be pie in the sky, and again, there's a lot of it take a lot to change the course of action. But a Chinese court, I'm familiar with one case where a Chinese court actually used blockchain as evidence in a copyright infringement action for factual evidence. They relied on what the blockchain showed. So I think these days are coming. I don't know how fast they're going to get here, not as fast as I'd like to see them get here, but I think they will come. So there's a lot of stuff going on in this space. I deal predominantly in the patent world, although I grew up in a small firm. I'm in a large one now, but I grew up in a small firm where I wrote people's patents, I litigated their patents, I did their trademarks, I did their licensing, all that kind of stuff. So I enjoy looking at all this stuff. And I think what is interesting to me and fascinating in looking at all this over the years is how active this space is from an intellectual property protection standpoint, given what is a very open source mindset as well. I think it's very fascinating to me to see what's going on. And frankly, a lot of the technologies I'm seeing, going back to some of those earlier slides, is really the intersection of blockchain principles, AI, machine learning, and IoT, Internet of Things. The convergence of those technologies are becoming very, very active, and I think that's where the future might come for some of this stuff. So with that, be happy to take any questions. I don't know how I'm doing on time, but.
I saw some people raise their hands, so I'm just going to come to the mic over here. I'll ask the first question on NFTs. We were having a little bit of a debate last night with the guy from CFTC here yesterday, and he's like, we're talking about NFTs and the value of, or like what it really means if you can copy and paste a JPEG versus the real utility of the NFT and enforceability around that. There's a little bit of openness. We had like an hour back and forth. I don't know if you'd like to comment a little bit on that. He argues if there's no precedent, anybody can just copy and paste it, and then he sold it to the person that was next to me for $5, but he doesn't own the actual NFT. But he's like, but I sold it and try to enforce it. You know, there's no real, too much governance there, yada yada. So his point was well taken, but I don't know if you can comment on this.
Yeah, the law is evolving on this, but I think it helps to understand a fundamental concept about NFTs to begin with. So let's take an example. NFTs, it's ERC 1155 is one of the protocols where you can get collections of NFTs and things like that. And let's just take an example of OpenSea. If I want to have an NFT and I want to sell it on OpenSea, what's going to govern what transfers? I think you have to look at a variety of things. Look at the terms. There's terms and conditions on OpenSea. Okay, understand what those terms and conditions are. Understand what you are as an owner of an NFT actually giving away when you give away the NFT. I would argue, and I'm here in a personal capacity, but when you have an NFT, what you have is a link to an interplanetary file system that is storing an NFT and metadata on the NFT. You are not necessarily getting the underlying copyright to the work. You are getting a pointer to where that NFT is being stored, okay, in a distributed file system. But transfer of IP ownership is something much different. I would also, something I came across, which I don't know if it will evolve or not, I came across it, and we're putting together in my firm a technical white paper on some of these technologies on NFTs, and I participated on writing the technical description of that. One thing I came across in researching this is something called refungible tokens. They're not part of the standard, but it was fascinating to me how you could, an NFT is something that's very unique. It's not divisible. You can't parse it, things like that. It's the Mickey Mantle baseball card vis-a-vis my baseball card. So one would command a high value, one would not. But it's not like you can cut up the baseball card. But what if you could? What if you could make a fungible token refungible and have multiple individuals collectively own the NFT or portions of the NFT? But I think it's a much different question on understanding legally what is transferred when one acquires an NFT. And I think you have to look beyond just the fact that you have the pointer or the token to an NFT. You have to look at the terms and conditions on things like OpenSea and whatever the artist might have separately done when they said, when you send the money to buy this, this is what you are or are not getting. Did you have a question?
I do. I am a provisional blockchain patent holder. And I have a question, maybe this is befitting for everyone, but in the face of blockchain, has the rule of 20 years on a patent, isn't that the rule? I'll trustfully, correct me if I'm mistaken, on holding this patent. Will that change again in the face of blockchain given the current rules?
What you're referring to is, a little bit of historical context.
Yes.
Prior to June 8th of 1995, I think was the date, we had a patent system in the United States that said your patent was valid and enforceable for 17 years after it issued. That law changed on June 8th of 1995 to say, you now have a patent that is enforceable for 20 years from your filing date. That harmonized the US patent system with what goes on in many of the other countries in the world. I don't think the blockchain is going to change that.
Okay.
In the short answer, I don't see that changing.
All right.
The term.
Great answer. Thank you.
Sure. Any other questions? Yes.
Ryan Cooper, DeVille Crypto Solutions. I have a question. You were saying read the disclaimer on Discord, I mean not Discord, OpenSea, but the artist could also have, additional rules. So my question is about a friend. He got a Bored Ape a while back, and he's actually
Doing very well with that.
doing merchandise. So he's got the image of his actual Bored Ape on skateboards. He's doing merchandise. Do you know anything about that area as far as like if the words in the agreement between me and the artist or Bored Ape Yacht Club, that I can use that image of the one I bought on any merchandise moving forward? Do you know anything about that area?
I know stuff about the area. You have to appreciate I can't be giving legal advice up here on limited information, and I'm not going to do that. But I will say that there are many ways and many platforms where you can sell an NFT. Okay, you can do it on your own platform, or you can do it through an OpenSea. And there are conditions which can attach to that, and there can be legal terms that attach to those arrangements. And I would just encourage you to not think with tunnel vision on something like this, to understand that when it comes to an NFT, you're getting a pointer to a token. If you want to get something else, or you think you have something else, consult an attorney, read, make sure you're well aware of all the documents and all the terms that may apply to that scenario. And it might not necessarily be the same answer in every situation.
Good question, actually, on the Bored Ape. And just a comment, this is Silvio here at Logos Capital. Just a comment really quickly on that. I think what makes Bored Ape very unique is the fact that they do allow people that have that to actually have copyright to like sell and stuff.
Well, and I think recently in the news, I think somebody, thought they acquired all the copyrights to Dune. I think that was in the news just recently. So you might look into that and whether that was really the case.
Yeah. My question is about a little bit of like collaboration on open source. There's a huge open source culture here. Different types of open source licenses, and perhaps how one can contribute to open source code, but still be able to retain some intellectual property that can be used maybe partially, because there's some combinations of adoption, mass adoption, to give, say, a large part of the open source under let's call it a MIT license, whatever the
Apache 2.0, BSD, whatever you want. Yeah.
A standard open source, but you can still have something in the back end, which might be the secret sauce or enable it or et cetera, which doesn't have to necessarily be open source. Can you talk a little bit about how these things might interoperate between some open source, the like actual business implications of contributing to an open source project, being able to contribute to an open source project and retain some IP for your part, and maybe the practice of something like
Yeah,
this?
there are a lot of open source licenses out there, and they all have their different flavors to them. I think some of the more popular ones that are a little bit more less restrictive would be obviously the MIT, Apache 2.0. I think those are some examples. But to briefly answer your question, depending on the license that might be attached to something, there is a possibility to protect software through the patent world, as well as licensing and open sourcing aspects of that software that might not be subject to what the patent is protecting. Okay, those two worlds can coexist in certain situations, and in certain situations they can't, based on what the license itself says. Okay, many licenses are, it's called, one thing is called tainting. You may or may not be familiar with that, but it's basically where if I have a license, I want to ensure that any downstream users of that have the same restrictions as the license that I'm granting, so that I can kind of control and know what those restrictions are as it relates to derivative works, things like that. Some licenses even address whether or not people can take the technology and try to patent or assert a patent against it, things like that. So it's shocking that a lawyer is going to say it depends, right? But it does depend. But I will tell you that there are situations where patents and open source licensing can coexist.
Could you comment really quickly on, I think someone mentioned to me this in passing, but that Satoshi Nakamoto's, there's some patent, I think, on Bitcoin protocol, and then I think that some of the user groups or the early users or early builders even then changed that original sort of terms and conditions of some of the initial protocol or software?
I don't know if, what I'm familiar with recently is Craig Wright, who claims to be Satoshi, initiated an action in the Chancery Court in London, I believe it was about a year and a half ago, against the core developers of Bitcoin, because basically one of his keys were stolen. Okay, they were hacked, and so he lost multiple millions, I think maybe even in the billions of dollars worth of Bitcoin. And so he was going back to the core developers saying, you guys can actually go back, since you're in charge of the code set, you can actually go back and perhaps correct this for me, okay? I believe from a technical standpoint what that would entail would be basically submitting a false transaction to the miners and convincing all the miners to accept it, so that transaction outputs don't necessarily equate to basically undo what's been done. But that's been in the context of him losing keys, and I think the Bitcoin white paper itself, I don't know if it's Craig Wright or others, I don't want to get into that, but I think there have been perhaps some actions relating to copyright infringements saying you can't keep disseminating this paper, it's copyrighted, and it's copyrighted by me, okay? And the question then becomes, how can you prove that you have standing to assert the copyright that you actually are the author? You know, and that opens up a whole nother Pandora's box on all sorts of things as to, you know, requisite standing to show that you are the creator of the work. I don't know if that's what you're referring to, but there's been a lot of activity in Florida, I know, and in a court in London right now. With respect to Mr. Wright.
I think it's interesting. As another point, a little bit differently from the white paper, that is fascinating though, is saying that there was an original code depository that was not on GitHub, before GitHub. It was on something else, and maybe somebody in the room might be able to comment on exactly what the code-based repository was. And then they moved that code base to GitHub. And in so doing, they sort of changed the license, some of the licensing rules, right, in that transition. And I think that from there on, that's I think of.
I'm not familiar with that part of the history, but what I would encourage people to do is for those of you who don't know, GitHub is a repository where a lot of these code sets live, and that's where you can see what some of the licenses are. But make sure you read that carefully too, because you might have one license that would attach to the code base, one license that might attach to code relating to the network itself or the APIs. The licenses may or may not be the same across the board regarding the whole ecosystem. Okay, so you need to navigate those things very carefully as well. I don't know if there was a license that was altered back in the day, 2010 probably timeframe is what you're talking about, but I'm not sure.
Well, thank you for that.
Absolutely. Thank you.